Number 1. No other discipline besides poetry so closely replicates the central question asked in the study of legal thinking. Here is a text. In how many ways can it have meaning? Other disciplines ask, what does this mean? Or what did the author mean by this? Or how can this be used? Or how does this fit in with what else has been said or done? All of which are useful, meaningful questions in their proper contexts. The formalistic study of poetry, however, disdains an objective concept of truth and concentrates instead on interpretation. It matters not what Keats or Yeats might have intended by a given line or poem. They are not around to tell us. If they were, we could not trust that they consciously understood everything that had gone into the composition process. And, as many now argue, the meaning of a poem results from a collaboration or series of collaborations between the writer who produced the text and a particular reader who perceives the text. Poems are not questions for which readers must supply correct answers. The same holds true for the study of law, though not quite as consistently for the practice of law. There is no answer a student can give that should elicit a "thank you, that is correct" response from a competent law professor. A demonstration of having done the reading assignment will get the law student past only the professor's first question. What happened in the case of Robinson versus Allied Furniture Movers? After that, it is all mental sparring, intellectual counterpunching. In the first year of law school, a student could get an A in every course without citing a single case in an examination. It is the ability to reason from different perspectives that counts. The minute a law student thinks she has the answer, she is lost. The professor will tap dance around that response to another perspective that makes her answer seem ridiculous. Keats' concept of negative capability, long taught in poetry analysis courses, prepares one well for this mental jousting. Negative capability is the ability, when you are faced with multiple possibilities of interpretation, even mutually exclusive possibilities, not to succumb to the compulsion to choose one at the expense of the others. It is the power to interpret a line or a poem or a person as being both X and not X simultaneously, without the contradiction suggesting a lack of truth. Poems are not crossword puzzles, which, once figured out, can be discarded as mere past experience. Neither are most of the cases studied in law school. Neither are people. Shakespeare has Hamlet complain bitterly about such treatment at the hands of his supposed friends, Rosencrantz and Guildenstern. They have just denied Hamlet's request that they play the recorders, pleading ignorance of the instruments. Why, look you now, how unworthy a thing you make of me. You would play upon me. You would seem to know my stops. You would pluck out the heart of my mystery. You would sound me from my lowest note to the top of my compass. And there is much music, excellent voice, in his little organ, yet cannot you make it speak. Is blood, do you think I am easier to be played on than a pipe? One cannot pluck out the heart of the mystery of a poem any more than of a person, nor can one do it to any legal question worthy of being included in a course of study at a law school. George D. Gopen.